part of any of those. I wonder what they are. Good morning. It's about 8:30. Let's go ahead and get committee started. Ms. Ogden, if you'll call the roll for us.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan,
Here.
Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Here.
9, and we have a quorum.
All right, good deal. We've got a pretty long and aggressive calendar, so let's go ahead and get started. I'd ask the members to hang with us as long as you can. I know there are other committee members, committee meetings that are going to be happening, but your attendance is vital. So first up on the agenda is SB 329. That is my bill, fairly simple bill. It allows, other than just federal law allows campaign and principal of campaign executive committees to receive the lowest rate when advertising. This would apply at the state level as well. Be glad to answer any questions.
I'll move a favorable report.
Thank you. Motion favorable in a second. Holly, if you'll go ahead and get the roll for us.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton,
Aye.
Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
All right, we favorable report on that bill. Next bill on the agenda is SB 324. Senator Coleman.
Thank you so much, Mr. Chairman, for the opportunity today. SB 324 came as a result of us hearing from the Secretary of State that President Joe Biden would not have the opportunity to be on the ballot in November. And so, of course, we as a state, we started rallying around, want to make sure that every citizen in the state of Alabama has the opportunity to vote for the candidate of his or her choice. So what this bill does, actually on page 6 of the bill, is really the gist of the bill, starting page 6 and goes all the way to page 7. And what it does is it allows for the certification of the nominee from the parties to be filed in the Secretary of State's office no later than 74 days before the date instead of the 82 days.
Mr. President, move a favorable report.
Got a motion for favorable. A second by Senator Bell. Senator Gavan, do you have a comment?
Thank you, Mr. Chairman. So there's been a good bit of talk about this and good bit of it on talk radio and all that. And I think people need to understand that this law has been on the books since 1975. Communications have improved just a little bit since 1975. I'd like to think that if the shoe was on the other foot, that this would be taken care of. And I think that Alabamians have a deep sense of fairness when it comes to politics and elections. And so I want to let everybody know I will be supporting this bill.
Thank you, Senator Gavan. Got a
Thank you,
first.
Senator.
Thank you. Yes, sir.
The timing actually gives to the end of the Democratic National Convention. That's what it does. Well, this is what, we talked specifically with the Secretary of State's office about. These are the numbers that we ultimately discussed, and that's how we end up coming to the numbers.
Thanks, Senator Connolly. Any
Renew
other
my motion.
questions, comments? Got a motion for first and second. Any opposition using previous rule? Hearing none, bill's given favorable report. Thank you, Senator Coleman. You're up next on SB 289.
Thank you. I have to thank Senator Figures in her absence today for working with the chairman to get SB 324 on. So then I ended up with 3 bills on. So I think I'm somebody today. but I got 3 at the top of the agenda.
It's the Senator Coleman Day, it looks
It
like.
is. That's what it looks like. So hopefully we will get all of them passed today. The second bill deals with with notaries, and what it does is the prohibition. It does not apply to professionals such as attorneys, accountants, real estate brokers, their employees who may lawfully notarize the documents that are necessary to be a part of their professional services. And that's in a nutshell. If there are questions about it, really, Senator Gavan has kind of the history of how we got here.
Move for report.
Second.
Motion favorable and a second. Any opposition using previous rule? Senator Albritton, you had a
Just
question?
not a question,
Comment.
just a comment. We passed this bill similar to
Similar, yes, sir.
last year or so.
Yes.
Okay, so this is kind of a cleanup.
Yeah, we
aspect?
found an additional problem. If Senator Gavan could further explain,
Sure.
because he knows the history of how it came about.
So the
Well, I made some comments last year when it came up about but anyway, go ahead. I'm sorry.
Well, so we were, this came up late last year, and there were some back and forth. There were some amendments. There were some concerns. I think it was one of those things that we thought, just in all the hubbub, we were taking care of, and that's been an open question. And Senator, specifically, I got the question I got from one of my professors called me and said, "Hey, we've basically settled a big lawsuit, and we've got we're getting releases signed on this. We're obviously going to get paid a fee on it." And so I think our intention was to ever try to undo what empirically had been happening, especially in the legal profession. And then it went from there to, well, what about stockbrokers that, have to do powers of attorney and things like that? And so where the idea came up is that, well, let's deal with licensed individuals. Now, a subsequent question has come up on people who are not licensed who do notarizations for title companies and who obviously get a fee as part of the closing. And that's something that I've told them I'd work with them on trying to work out some language. I think that some language was sent to the sponsor and to me, and I think we both objected to it. So we've got some work to do on that.
Does it prevent a licensed notary, from charging a fee to do the notarization?
No.
Okay, just double check.
Any other questions, comments, concerns? I think we've got a first and a second. Is that correct? Okay. We've got a first and a second, so we're on the bill. Any opposition using previous rule? Hearing none, bill's given favorable report. Thank you. Senator Coleman, you've got the next one up, SB 14.
Thank you so much, Mr. Chairman. SB 14 does not have a public hearing on it. However, there are quite a few folks that are here today that have a personal interest in this piece of legislation. And I want to acknowledge them in the room and if the chairman indulges, if the committee allows maybe one person to say something, that will be at the pleasure of the chairman and the committee. But this piece of legislation is the Juwan Dallas and Stephen Perkins Act. Just a little bit about how I got here and was sponsoring this piece of legislation. I actually was at a meeting in Mobile that was called by the Poor People's Campaign, and Reverend Barber came in, and we were talking specifically about what happened to Juwan Dallas in Mobile and the impediments that the family faced for trying to gain access of the body cam video. And the attorneys there said it actually was the piece of legislation that we passed last year, or year before, that ended up being the impediment to them getting access. And so as a lawmaker, the only one that was in the room, I asked how we could help. And that's how this piece of legislation came forward. In addition to that case, we were hearing about what happened to Stephen Perkins in Huntsville as a result of, I'm sorry. Correct me. We were hearing about what happened in his case, and again, impediments that the family had there as it relates to body cam. I want to say this: this piece of legislation is not an indictment on law enforcement. What it does is allow body cam video to become a matter of public record within 30 days. So the press has the opportunity to view it. The public has the opportunity to view it. This family had an opportunity to view body cam footage as a result of a leak. The Dallas family, it was 6 months before they got a chance to view that body cam video. And I just believe that the sooner that we get that out, you kind of can squelch some of those rumors. 'Cause sometimes, prior to people, the unrest happens because of the rumors, what really happened. And if we can get that body cam video out as soon as possible, then we can identify bad apples. And if the police have operated within procedure, we can identify that as well. And in Tuscaloosa, I'll use this case. Tuscaloosa is my home. There was a situation there where a young man in pursuit, he was being pursued by the police in Tuscaloosa, and he passed away. And so the public had all of these rumors out there about what happened to him, and the police, had a hand in it. And Representative Chris England, who I served with for many years in the House, was a part of helping to get that footage out early, and it was prior to that last piece of legislation, and it was able to show that indeed the young man actually passed away as a result of a heart attack. The public discourse because the video was allowed out immediately. So again, my legislation would allow it to come out within 30 days. So again, we can identify those bad actors and give these families some sense of release and ultimately justice. So I do want to acknowledge Mrs. Perkins, who is here, Stephen Perkins' wife, Catrella Perkins. We also have Anissa Lige, Terrence Atkins, Rodney Gordon, Danny, I'm going to say his last name wrong, Sophia, Michael Stovall, Alvin Mosley, and Mr. Perkins' brother, Nicholas Perkins, is also watching online with other family members. So I would ask the committee to give this bill a favorable report.
Thank you, Senator Coleman. Senator Bell.
And I understand the reasoning. I think the 30-day public record, and I'm just thinking of cases I've been involved in, even as a defense attorney representing someone, there's many times I don't want that out because it will hurt me in my defense of someone. And it goes both ways. It goes both ways. Um, and I understand that there should be a mechanism for the family to be able to see what's happened. I can think of two cases. One I'm currently involved in that if the body cam got out early, the whole prosecution, it would have hurt both sides bad based on that body cam. And I'll be glad to, in private, explain that one to you.
Well, I'm a lawyer as well.
I
I
know.
do a little criminal
And-
defense work
and
myself. But-
I think there are some ways and maybe some things to work on, but as far as on this one, I'm just letting you know I can't do it.
Let me respond to you.
Yeah.
When I first introduced this, I pre-filed this piece of legislation, and I appealed to the DA's Association and whomever to, if the 30 days was an issue, for folks to reach out to me. Let's see what we can do. Let's talk. I haven't heard from one person.
And I don't know that you could, like, this one's been 2 years going on, and it's not released yet. But there's really a good reason. I don't know that you could put a day limit on it. And I thought the bill that Representative Wonga Van did last year fixed some of that for the families. And I'll go back and look at that bill.
You need to. You need to.
But that's. And I'm just thinking of cases I've been involved in and how that being released.
Yeah.
And unfortunately, most of the time I've been involved in it, it's actually hurt me on who I'm representing when it got released. But to protect my client, I didn't want it released because then it'd be prejudice in the community on my client before trial from the defense side.
See the.
Senator.
I was gonna I appealed early on before we even came into session. Hey, someone come talk to me, please. I did it publicly on television. Hadn't heard from anyone.
Senator Smith.
I too, I'll tell you that I'm gonna vote to get the bill out of committee, but Senator Bell is right what he just said, and the problem is it's just like I hate to use our former president as an example, but that's what he be screaming, talking about how am I gonna get a fair trial if everybody already made up their mind and I got to get jurors, and unless I change venue and go some other state or somewhere else, it's not gonna happen. And he is right about that part about having a problem with the jury and even your defense strategy when you're trying to develop that defense strategy. Sometimes people don't understand, but that's why you have both things on the scale of justice. The person charged has just as much right as justice, and reasonable just as the person who's the victim too, because that may not even be the person. And so I do see problems with that. I don't see problems with the family seeing it wherever they want to. It can be the next day. But to release it out here to the world, no. I think there's no way that you're gonna have an equitable trial and everybody out there. And no, I hear what you're saying, but you can never squash opinions of people. They're going even if you see it, you're gonna have the same kind of situation with that aspect of it. So it does have some problems from that standpoint. And I've said that after I've been practicing almost 40 years. I've been a prosecutor, our firm as well. So I know both sides of the coin in terms of what we're talking about here. So that's something that's got to be addressed. I'm just telling you that that's a flaw, and I hear what you're saying about you put it out there, but I'm gonna just be realistic about us. I ain't talking about the DAs or anybody else. Ain't no way we gonna be tracking a comment about a bill, when we deal with about 2 to 3 thousand bills in here. We don't have our own individual person that analyzes every bill. We have to go to a department to get it done, and we have to get in line. So I just wanted to say that to you that I hear what you're saying, but at the same time, I'll put it this way: my first impression is when I saw this this today and read the bill, not today, but when I saw the agenda, then I focus on that agenda. What is it in there that's got to be addressed? So prior to that, I didn't know anything about the 30 days. I knew you had a bill out there for that, but the 30 days. So I just want to say that to you that everybody ain't picking up on something because we make an announcement about it. And so I just want to say that to you that it's some
Yeah.
problems with it because of what I just said. I am going to vote for you to get it out of committee, but before it hits the floor, those things going to have to be addressed, or in some shape, form, or fashion to give them what they want and to give that person a reasonable amount to have a reasonable chance to have a reasonable defense.
I thank you for that, Senator, and I really will. To my former college professor will appeal to him to really help on the amendment portion of it. We get it out today, and of course, as a member, I know how many directions we all are pulled in. But when it comes to the DA's associations and the other law enforcement officers, I mean, again, that's been out there for a very long time, and then again, hopefully you can help me, Senator, in what we need to do to give these families some level of justice or just some relief as they're going through this. When I listened to Mrs. Perkins and even Nicholas, his brother, and listening to Mrs. Dallas, who did view the body cam video of her son, and can't sleep because of it. But 6 months of waiting is just way too long. So I just appeal to you, to my college professor, to help us shape something, and shape something instead of just saying, no, we can't do that. And that's what I hear sometimes from the other folks on the other side. No, we just can't do it. But then we're expected on our side to always work to try to get amendments. Well, let's do that also on this bill that can be helpful to these families. And that's my appeal to the committee.
Senator Coleman, I've got a couple other folks who want to say something on this bill, but my concerns are the same concerns raised by Senator Smitherman and Senator Bell. What you have is if a video is made public after a 30-day period or made public, then I think a lot of times you hamper an investigation, you hamper the defense, as so eloquently stated by both the lawyers that have spoken so far. You also victimize again and again and again those people who have been the victims of that crime that's been perpetrated against them. As I understand it at least, the current law allows for family members or that individual or representative of that individual to view the footage. I was supportive of that, I believe, last year, and I think that was a pretty good piece of legislation there so that the family members could actually know what happened. So
Mr.
I
Chair,
have some
may I just
concerns about
respond to that piece?
Sure.
Because we all did. But the families, in various situations now are saying, even the attorneys that were in Mobile this past fall, said that some district attorneys are actually using the piece of legislation that we passed as a means to keep from releasing the body cam footage. That's why, again, when I was appealing to those folks from those they get in contact with me when they want something done on the budgetary side. And so on this side, I didn't hear from anybody. I'm just saying that we got to do something because, again, some DAs are using that piece of legislation as a means to not release the body cam.
Senator Orr.
Thank you, Mr. Chairman. I was aware of this bill and appreciate your bringing it. I intend to vote for it. The days can be quibbled about, but what gives me some solace in the bill is that if there's a dispute between law enforcement saying, hey, this is going to compromise our
Yes.
investigation, we just go to the circuit judge
Yes.
and let them decide. So we've got an independent arbiter of, well, it may hurt the defense or it may hurt the prosecution and or they're still under investigation. Whatever, we involve the judge and let the judge decide. But we don't run into stonewalling
Yes.
of just a video camera because we just don't want to give it up. And I think you're addressing the issue and have a safety, outlet or measure here with just take it to the judge
Yes.
if it causes a problem between the prosecution and the defense. So thank you for bringing it. And
Thank you,
Look
Senator.
forward to supporting it.
Senator Bell, and back to Senator Smitherman.
And same as Senator Smitherman, I looked at the bill last night for the first time when I got going over the calendar for today. So that's why I didn't know to come. And then the one good thing I did learn, I was 12 when Senator Smitherman started practicing law.
Senator Smitherman.
I want to say this, Senator, since you so eloquently stated our relationship into the law, I want to, and I thank you, but I want to say this, that I'll be glad to work with you, but of course, what I guess the public don't know is that the law we talking about is constitutional
Yes.
law.
Yes.
And having taught that for 25 years,
Right quick.
I tell everybody here, I don't know more than anybody else in this building, but there's nobody in this building knows the Constitution more than I do after teaching law students for 25 years constitutional law. So I'm speaking from that perspective,
sir.
from the Constitution, because everybody has the same equal rights under the Constitution. And also, if you all hear me out so eloquent, make this example, and I'll do it probably as long as I'm in the legislature, is that this bill is like an airplane. The pilot on the airplane that's why they laughing. The pilot on the airplane looks and asks if the runway is open. The runway is to the end of from here to your bill. But as I always said, that the airplane has wings, and nothing is being seen as what's under the wings. So the incidental damage that's done to people that's on the outskirts of where they see is tremendous. It's not intentional. It's not that these people going down the runway see anything under here. They don't. But under there is all these things that we're talking about. And because we are going after one situation or to satisfy one group, the incidental happenings to all these other people who are under these wings have to be taken into consideration. We can't take a razor.
agree.
We can't take it, not just in this situation. I've said this on numerous.
I'd agree. Yes, sir.
We can't come here because one group or one set of people got this problem when this problem is going to affect 5.5 million people in the state because it's a state. It ain't just affecting that situation. So because of that, we make laws that pertain to 5.5 million people, not 5, but 5.5 million. And as a result of that, all those areas have to be addressed and to see if they can be, dealt with so that then we can move forward with this. So I do look forward to working with you on that, but I would say that still is a concern that I
Thank you,
have
sir.
regarding that. Thank you.
Senator Weaver, then Senator Coleman Madison.
I do have some concerns based on some recent conversations that I had with some victims in my district. They have concerns because they're in the heat of the moment when the body cam is on. There's some very private and confidential things that are shared on that video. And from a victim standpoint, they had concerns that that information would then be so readily available for everyone and some things that they felt should be confidential and a protection for them. So I do have a few concerns, but would love to work with you on seeing what we can do to protect victims in this case.
Thank you. And of course, that's what I definitely want to do. This is about victims.
Senator Coleman Madison.
Senator Coleman, I do have an amendment. I'm just trying to listen, not an attorney, but just trying to address some of the concerns that you have, and maybe, as you said, come with something that would maybe address. I'm going to ask
You walking, you
the
walking on.
drafter so that he can read this. I can't read everybody's handwriting.
Give me a second to get there, please, please, please.
Thank you. And I'm trying to address the concerns that Senator Bell and Smitherman asked about, as well as on that this is not made public. It does not prevent families from viewing it, I guess, but it's a matter of putting it out there for the public. So I offer this.
Senator, may I comment?
Sure.
You can. And let me just say this, and I realize, last minute, but I said earlier on in the session, my understanding from LSA is that any handwritten amendments were strongly discouraged because of making them fit. We've tried to make that across the board the policy. So I would just suggest that if this bill gets out of committee, that if it can be in LSA format on the floor, I think that would be helpful, because that's,
Ms.
Put it in
Chair,
that, but I'm hoping that, I mean, if anybody had any questions about what this is about or the intent, and hopefully that it will address the concerns that learned members who are in the law area that deals with this every day. I can understand we don't want to prejudice your investigation or what you're doing as far as your client. So I offer this amendment, sir.
well, it will be considered an unfriendly amendment, and I thank my colleague for trying to address all the concerns. But in my opinion, that amendment guts the entire bill.
let's, based on that, if we could hold off the amendment, especially since it's considered unfavorable by the sponsor, that's a consideration. And for me, procedurally, just the fact that it's handwritten, I think, again, LSA folks have urged us, please don't have handwritten amendments. To the extent the bill gets out, there's an opportunity to put that on the floor. So I'd ask for consideration of that.
That's fine.
Any other, Senator Cornley?
I was just going to ask, is there a possibility of taking some of this here and amending the current law? The way I understand it, your goal is to try to get this video in the hands of the family members, correct?
That's the major goal, yes.
So, but this makes it public record.
Correct.
So if we amended the current law, would you be more agreeable with doing that, or do you still want to make it public record?
My major concern, of course, is allowing the families to have access. The purpose of making it a matter of public record is what I mentioned. Oftentimes, we can stop a lot of the rumors and some of the public discourse if it's a matter of public record. But again, my major concern is making sure that the families have access to the body cam.
Any other questions, discussions?
And Ms. Chair, I'm sorry.
Any other questions or discussions? Okay. Senator Coleman.
Thank you, and sorry for the interruption to the chair. I would just, again, appeal to the committee if we could get the bill out. I'll be willing to work on whatever piece of amendment to achieve the major goal of getting that body cam video to the family members, to give them some level of relief and some information about what happened to their loved one. So that is my major goal at the end of the day. And
Thank you. You got a motion for favorable, Senator Orr.
Second.
There's a second by Senator Coleman Madison. Ms. Ogden, if you'll call the roll.
Senator Albritton, Senator Bell, Senator Cornley, Senator Coleman Madison, Senator Elliott,
No.
Senator Figures, Senator Gavan, Senator Orr, Senator Singleton,
Aye.
Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
No.
4 to 8.
4 to 8. Thank you, Senator Coleman.
Thank you all so much, and I look forward to you all coming back next year, and hopefully you all will help me get a piece of legislation that will help these families in the long run.
Thank
Thank
you.
you.
Thank you, Senator Coleman. We're going to do something. I see the rules chair sitting over there, and I think I've made him wait a little too long already. Don't hold it against me, Senator Wagner. And then we're going to go to Senator Smitherman. Yes, sir. We have a motion for a favorable by Senator Smitherman on this is on Senator Wagner's bill. Sure, and I think, and let's just to be fair about it, I want to say I think there's some potential opposition and the way of we passed what I think was a good distracted driving bill last year at your leadership and direction, and thank you for that. I think that was a great piece of legislation. I think there's some concerns that this may go a little too far, but Senator Wagner.
Thank you, Mr. Chairman. Members, this is the new and improved distracted driving legislation recommended by the Alabama Law Enforcement Agency, ALEA. They, every day, they know what's happening out there on the highways and byways of Alabama, and they've come to me and they have some new recommendations to improve and help the driving public. So as y'all remember, I sponsored the original distracted driving bill. I guess it was last year or 2 years ago. But ALEA has come to me and said we need to, make some improvements because they, not us, they know what's happening out there on the highways in Alabama and to save lives. No telling, I was involved in the seatbelt law back in the 90s, and there was pushback. Nobody wanted it for about 10 years. And then in 1999, we passed the seatbelt law. How many lives have been saved in Alabama because of the seatbelt law? And I look at this legislation as something to prevent accidents, save lives. And that's the reason ALEA has come to me with this improvement on the distracted driving. And with that, Mr. Chairman, I'd like to call Sam Adams, who's the attorney for ALEA, up for a quick statement.
Yes, sir. That'd be fine. I know Senator Van wanted to make a comment or question. I don't know if he wants to hold off until after Mr. Adams, and I think if Senator Smitherman wants to follow up with that, and then we got Mr. Adams. Come on up and address the committee, and appreciate your being here. And not to rush you, but we've got a pretty aggressive agenda, as I said earlier today.
Sure, and not to contradict Senator Wagner, but I am not an attorney. I just want to make that clear to the Judiciary Committee.
Your standing just went up.
That's a felony in Alabama to pretend you are, so I just want to make sure you know. As Senator said, last year the legislature passed and Governor Ivory signed SB 301 that established that it is prohibited to hold a device while driving. However, law enforcement must not only see someone holding that device, but also see them do a few other actions or possible actions, including swerving, illegal lane change, those sorts of things, before they can actually pull them over and cite them for that. This bill just takes away that portion that says that law enforcement has to see them swerve, do an illegal lane change, or show possible impaired driving before pulling them over and citing them.
And my just real quick, and I'm kind of jumping in. I am concerned that could be used as a tool.
Yes.
To pull over vehicles that have otherwise not done anything, that have been in violation of the rules of the road, otherwise not causing a problem for other drivers. And so that's my concern with it. Again, I think Senator Wagner did a great job last year of making sure that that bill accomplished something that we're working off of, or these y'all are trying to work off of now. And I applaud him for all the efforts he took last year to make Alabama a safer place on the roadways. I just have some concerns making this a primary offense without a secondary, instead of a secondary. Senator Gavan.
Thank you, Mr. Chairman. So, Mr. Rules Chairman, I appreciate you working with me last year on making changes to the bill, and the House pulled a little switcheroo on us that I didn't quite catch. But we worked with a lot of different folks and a lot of different members on addressing their concerns about this, and this was carefully negotiated. Now, last year I was the only one on this committee dumb enough to vote against the Rules Chairman's bill. I did not learn my lesson, but just know I'm not voting against you. I'm voting against Aaliyah. So.
Just for the record, I'll be voting no, but it won't be against Senator Wagner, the Rules Chairman, or against Aaliyah. It's on behalf of the citizens of Alabama. So, Senator Smitherman.
I noticed what you all were saying in that regard, and I was going to ultimately say to the sponsor that, if we, I'm going to vote to get it out, but if we go forward, then we've got to tighten that part up, because that was one of my concerns for 9 years. For 9 years, I had a similar concern as we talk about the secondary offenses to these kind of offenses. And you said how you had concern for 9 years, because I was chairman of Judy for 9 years. When that bill passed, I was chairman of Judy back then. I stayed until 2010. So I understand everything that everybody's saying, and I actually had concern even about the initial when we started with the seatbelt, it being a secondary, versus primary. Now one of the things did change me about that was that I was getting off Green Springs Avenue, headed down to UAB at the next exit, and my daughter, middle daughter, was in the car, and I didn't want to wear no seatbelt. I'm just telling the truth. But back then, no, seatbelt is an impediment. And she said, Daddy, she said, and y'all correct me. She said, do you know, I think it's Newton's theory of gravity. Yeah, I mean, because, I'm not bragging on her, but she, 29 on the ACT, 4.4 on a 4-point scale. She was pretty smart. She said, you understand that? I said, what's that? She said, when we get off this exit and you see that metal pole, that light holding the pole, she said, the car's running 60 miles an hour. She said, when he hits that pole, I'm going to stop because I got this seatbelt on. She said, but a head imprint of your head is going to be in that windshield because your body is moving 60 miles an hour. The car's moving 60 miles an hour. Now, the car stops. What is going to stop your body from moving 60 miles an hour through there? So that at that point, I reached over there and buckled up my seatbelt. And I had it buckled ever since. So I applaud Senator Wagner for what he's trying to help Aaliyah do. But that is a concern. I coming from the hotel to here this morning, now you're supposed to be hand-free, so I bought me one of those little things you put in the drink holder that holds your phone. And the first thing happened to it, I hit one of the bumps, that little bracket. It didn't do good, and it popped out of it. It was about to fall on the floor. I grabbed the phone, guess what, off the floor. I got a ticket. If the police sitting right there and they see me grab that phone, I got a ticket. So it's got to be something to balance that, not just the fact it's in your hand, and all of a sudden it's a primary offense. I appreciate law enforcement trying to do everything they can to do that. But that goes right back to the one I was saying about Senator Coleman, is that, the airplane wings. We're talking about wings now, and not the plane itself. So it does need some additional work on it. But I am going to vote myself to get it out of committee.
Thanks, Senator Smitherman.
Mr. Chairman, I appreciate y'all concerns, and thank you for bringing that concern out in terms of the secondary piece. But I would say to Aaliyah, I think y'all need to clean up Aaliyah first. I see more officers riding down the road with phones up against their heads. And maybe you need to talk to them first before we talk about cleaning up the public. Thank you very much.
All right. Any other discussion on the bill? Hearing none. Ms. Ogden, if you'll call the roll.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
No, despite my favoritism toward the sponsor.
3 to 7.
All right. Bill does not receive a favorable report. Thank you, Mr. Wagner. Next up, we're gonna jump around a little bit. Senator Smitherman has a committee hearing to get to. I believe, if I'm not correct, am I correct that we've already seen the House version of this bill? It's SB 3.
It is a House version of it.
317.
We have.
I vote for favorable.
Got a motion for favorable by Senator Bell, second by Senator Carnley. Holly, if you'll call Ms. Ogden, if you'll call the long roll for us.
Senator Albritton, Senator Bell,
Aye.
Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman,
Aye.
Senator Stutz, Senator Weaver, Senator Barfoot.
Aye. Bill's given favorable report. Thank you, Senator Smitherman. We're going to jump around a little bit. Representative Chestnut has another committee meeting. Representative Chestnut, welcome to the Senate Judiciary.
Yes, sir.
Floor is all yours.
Yes, I have HB 172, and this bill deals with materially deceptive media, or in the words of media, they call it deep fakes. This deals with trying to deal with the actual deep fakes in the context of election, that we don't have candidates who are engaging in deep fakes, materially deceptive media, in order to depict wrongfully or incorrectly their opponent in a way that would make a person believe that their opponent engaged in something that was really unseemly or unsavory, to the point that it changes the outcome of the election. And so this is something that would give, like, the Attorney General, or either like the actual person who is committed against, the opportunity to file an injunction. There are also some criminal penalties that are associated with this. And so if there are any questions about it, and
we have an amendment, right, Mr.
I
Chairman?
believe there's an amendment in your package.
I'll move adoption of the amendment.
Good. Senator Orr, is that your amendment?
No, it's not.
The amendment,
Representative Chestnut.
yeah, I had a conversation with the amendment. That's Senator Carnley.
Yeah,
Senator Carnley, if you will, explain that
what
amendment.
this does is that we did this on another House bill that was dealing with AI intelligence, and what it does is it protects the creator of the software. So there was an amendment in there for, like, the internet companies. Just because they provide the internet service didn't mean that they were participating in the material or the creation of the content. This would like for the Microsofts, the Googles, the people that create the technology, even though they're not participating in creating it, just providing the software to do it, this would prevent them from being liable through that.
Sounds like a good amendment. I got a motion for adoption of the amendment by Senator Orr, second by Senator Smitherman. All in favor of using previous roll on adoption of amendment?
Aye.
All right. Amendment's adopted. Back on the bill.
Favorable.
Got a motion for favorable on the bill itself by Senator Orr, second by Senator Smitherman. Further discussion on, excuse me? All right, let's get back on the amendment then. Ms. Ogden, if you'll call the long roll.
Senator Albritton, Senator Bell, Senator Carnley,
Aye.
Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr,
Aye.
Wrong.
Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Aye. All right, amendment's given favorable, is adopted. Got a motion by Senator Orr, and second by Senator Smitherman for the bill itself. Any opposition using previous roll? Hearing none, the bill's given favorable report. Thank you, Representative Chestnut.
Mr. Chairman, we just want the representative to let them know how good we treated you in here now.
Don't
You
forget
go
it.
downstairs to spread the good love.
I will. All right. Thank you.
Skip around just a little bit more. Let me come back to SB 312. That's my bill. Let me be glad to explain that. It allows an inmate in DOC's custody who is up for a pardons and parole hearing to attend that hearing virtually.
Mr. Chairman.
You got a motion favorable?
Yeah, I moved.
Me.
I saw that in action Monday.
We got a one or a
Just
two.
said.
One here, two here. Let me say this before we vote because I've made a commitment to share this information. I think there are some concerns from DOC side, not about the bill itself, but that they may not have the technology in place. And it's above my pay grade, obviously, but may not have the technology in place to accomplish this without some additional funding. I've said that I would make the committee aware of that, supportive of the bill as it is. We've got a first and a second. We've got two folks who want to speak, Senator Smitherman and Senator Coleman Madison.
I just said it. Let's get them the money then. Let's get them the money. I mean, I'm all for that. I'm saying that now. Get them the give them the money. They need the equipment. Let's get them whatever they need. That's my recommendation to them. They need that. They need more high power gun. Whatever they need, we need to get them. I don't want them to keep protecting us. So whatever they need.
Senator Coleman Madison.
I just want to say that this would save money in the long run. They can take this money out of transportation. They spend a lot of money in transporting the prisoners. So this is going to save. So this is going to. So this is going to save money. So if there's additional monies that we need to add to them to get the equipment, in the long run, the cost of all of this is going to go down.
I would say, and not to lobby against my bill, but I don't think those inmates get an opportunity to be heard in person at pardons and parole hearing. I think those hearings are typically about 2 minutes, and an inmate is not there. So,
Well, the technology can be used even if you're having to go to court.
and my suggestion is when I file this bill is that sometimes when you're in a sentencing hearing in front of a judge, the judge sometimes finds it beneficial, I think, to the defendant's chagrin that to hear what the defendant has to say and to make an informed decision of whether or not that person has been rehabilitated and what they've learned while they've been inside of DOC custody. So that's the genesis of the bill. Senator Weaver.
Mr. Chairman, with all due respect here, I have a hard time voting on something, telling somebody they have to do something and they don't have the technology or the means or the money to do it yet. So until we can have a discussion with the chairman, who has perfect timing here, about how we get them the money and the tech. Yeah. So I have a hard time making them do something that they don't have the means to do.
Understand. Senator Smithman.
Buy them some iPads.
Any other questions or comments, concerns? If not, Ms. Ogden, if you'll call the long roll for me.
If I may,
Yes, sir.
I just walked in. How much were we spending?
Well, yeah, that's a correct statement. That's up to you, if anything.
I've heard that before too.
I can assure you, based on this past budget, it is up to you. I didn't have much of a say so with that. But,
I heard that you were a slow learner, but I disagree with that.
Yeah, well. All right, Ms. Ogden, if you'll call the long roll.
Senator Albritton,
Aye.
Senator Bell, Senator Carnley,
Aye.
Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Aye.
9-1.
All right, bills given favor report. Thank you, committee. SB 321. Let me do this. I see my chairman over there, transportation chairman. Let's go, Senator Allen. I'm gonna skip me. Senator Allen, you got SB 227.
Yes, sir. Thank you. The genesis on this piece was noticed in the Sunset Committee. And Mr. Chairman, I want to thank you and the committee for that. And of course, the Alabama Athletic Commission, and which deals with the boxing. By the way, Deontay Wilder is be boxing in Saudi Arabia June the 1st, and by the means of this act, it gave Deontay and others the opportunity to fight and in this state. So this bill has 6 points that was somewhat overlooked, but this bill, the basic meaning of what we're trying to do is protect the participants on the as far as the safety and protecting them. And it's got 6 major points in it, and I'm just going to go through them quickly.
Senator Allen, I'll have a motion for favorable report. There's a second by Senator Orr. Senator Smitherman, did you want a second, or do you have questions?
Sure did.
All right, we have a first and a second. Any discussion on the bill?
Mr. Chairman,
Yes, sir. Go right ahead.
this includes fines of $25,000. Is that correct?
Yes, sir.
And now a felony. Is that correct?
Yes.
Well, these boards have a way of never exceeding it, but getting right up close to it. Yes, ma'am. As long as I'm here. Mr. Chairman, I just asked for the long roll on this one.
Sure.
Mr. Chairman, may I?
Yes, sir.
One comment. Is it true or not true that a board or commission that has a counselor, a lawyer that they mostly have, has to be a part of the Attorney General's office?
Yes.
Correct?
Mm-hmm.
And they have a badge and a gun. Correct?
Yes.
Okay. And now, in most instances under the boards and commissions, those are civil issues.
Yes, sir.
And this, you're turning this into felonies, of Class C felony if possible.
Yeah. Yes, sir.
So my question is, does this make this does make the hired attorney become a prosecutor for the state?
Well, actually, yes, sir. That's
Okay.
one of the points. Yes, sir.
That's what I want to point out.
Yeah.
I have some issues with that authority, but that's just
Understand. It's been said you have issues with authority, so. Just kidding.
No, you're absolutely correct. You know me too well.
Just kidding. All right. Any other further discussions, questions, or concerns? If not, Ms. Ogden, if you'll call the long roll for us.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott.
No.
Senator Figures, Senator Gavan. Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Aye.
7-4.
Bill's given favorable report.
Mr.
Thank you,
Chairman, thank you,
Senator.
thank you.
Thank you. All right, SB 321 is my bill. Let me do the best job I can to explain this in a succinct, limited amount of time. This bill deals with the selling of controlled substances. There's already a unlawful distribution of a controlled substance act. Under the, excuse me, mandatory guidelines for unlawful distribution of a controlled substance, it is rare that a judge would find himself with the ability to, if the case warranted, to give any amount of jail time or prison time. This bill allows the carve out for controlled substance if you are selling that controlled substance for the judge to consider or have the option, judicial discretion of a statutory guidelines case. Not have to, but could. One of the concerns in there was that if you make the selling of a controlled substance a guidelines case, that there are mandatory enhancements or could be mandatory enhancements for the sale within a housing project, 3 miles of a housing project, or 3 miles within a school. That was a concern because under statutory guidelines, for instance, it would be a Class B felony, 2 to 20 years. So if a judge gave 2 years of time, they would have to add on the additional 10 years if it was sold within 3 miles of a housing project or of a school, which then would put it to 12 years. We didn't want those enhancements to have to apply. So we wanted to give the judge some discretion, and this bill, I believe, does that. Senator Smithman.
So it gives them some discretion from the mandatory part because of what you said in those radius and different things like that.
That's correct. So typically, I think what you'd find on offenses of distribution of a controlled substance, if it is a guidelines case, as you know, and I think the guidelines generally serve as a good framework for a judge to consider. But in those cases where the judge believes that there could be something more and that jail time might be warranted, it allows the court to say, we're not going to use these mandatory guidelines. We're going to sentence them under the statutory sentencing scheme, 2 to 20 years. The concern is that if we allowed the judge to consider to do one of the other of those, that if they use the statutory scheme, that there might be some enhancements that would mandate up to 10 years in addition. And we didn't want those enhancements to apply because we think, it would be potentially an over punishment if you took it away from the judge or made the judge do those enhancements. So
I want to say that I think that you did a good job of thinking about this. A lot of, I'm talking about even in our profession, a lot of people don't analyze and think about it the way you said it. I just quickly will tell you this. I had a situation in Shelby County where I was representing a minister of one of those larger churches there. And it was in distribution. And the reason was this, is that her husband had cancer. He had gotten his cancer medicine, yes, and he was selling it. She didn't know anything about that. I mean, she's a minister, a respected minister. And they had an undercover to come in and to try to buy from him. And because he was so weak and he was getting toward the end part, he was about to fall. And she just happened to be coming through. She didn't know what they was doing in there, but she came through there and called him when he was falling. And he was kind of mean to her too. And he had been mean. And so he said, give him this. She didn't have a clue. I don't know if it was a bag or envelope. I don't know what it was, but she didn't have a clue. And she told him, get out of my house because you see my husband is about to die. And so he died 2 months later. And the DA came back and charged her with distribution. And the jury found her guilty. And the judge, same thing he was saying. The judge said, I'm just saying what the judge said off the record. He said, I know this lady ain't guilty of this. I mean, I live here. I know that. But he said, I have no choice. Just like he was saying, I got to give her 5 years. I could not send her to her own conviction, but the 5 years. The only thing saved her was who went to the Pardon and Parole Board, and they said this is nonsense, and it was a matter of 20 days, and they pardoned her. She went on, but you're right. So I just shared that to say it happens, what you said, and I think that this bill will address that and let the person that's supposed to be charged and dealt with that way, and after the court hears the facts, the person that shouldn't. So I will move no favor report at the proper time.
We got a motion for favorable, Senator Smitherman, and second by Senator Coleman Madison. Any further discussion on the bill? Hearing none. Let's, Ms. Ogden, if you'll call new roll on.
Senator Albritton. Senator Bell. Senator Carnley. Senator Coleman Madison. Senator Elliott. Senator Gavan. Senator Smitherman. Senator Stutz. Senator Weaver. Senator Barfoot.
Aye. Nothing like having to think about your own bill. Bill's given favorable report. I am going to step out to another committee meeting. I'm going to turn it over to the vice chair, and y'all don't get too comfortable with him. So y'all give him a hard time.
Mr. Chairman,
Yes, sir.
So that everybody wasn't thinking I was being AWOL. I'm following you.
We're going the same place.
Yes.
All right.
All right, thank you, Mr. Chairman. All right, clerk, if you call the next bill. Oh, that's wonderful.
Let's continue then. Let's, members, if you need to leave, you leave. We'll handle it as far as I can get to. Next bill on the calendar is going to be Senator Hatcher, SB 182.
Good morning, Mr. Chairman, committee. Thank you for this opportunity. Let me say very briefly. I just got to this legislative body about yesterday, and I've kept wondering, who is Judy?
I'm like, yeah.
She is pretty famous. This bill was brought before the Senate 7 years ago by Senator Dick Brubaker, and it passed successfully in the Senate, and it died in the House. The substance of the bill is the same, dealing with requiring a unanimous jury sentencing vote to impose the death penalty. This is SB 182. The only difference would be I'd like to make it retroactive, but the substance of the bill is absolutely the same. So if there are any questions, there are some people who are much smarter than I am behind me because I play a lawyer on television. But we want to be sure we get you.
Remember, that's a felony.
That's I didn't say that.
Okay, are there any comments or questions? Mr. Chairman?
Thank you. The concern I have is retroactivity. If this is retroactive, does that mean that the convictions that have been made will be retried?
No, I think it's speaking to the fact that I think that was a figure I saw that said we had about 80% of those individuals who received unanimous jury verdicts for death. And what I think it would do is to go back. I don't know if that would be a retrying.
That's my question. To go back
for resentencing?
That's the question. When you put the retroactivity on what?
Can we work on that?
I think we need to. I think we need to. If we, we've got clogged up systems already. If we start running upstream on these matters in particularly, you're looking at, I think, a major issue that we need to get resolved before we go forward on this. That's my comment.
Thank you. Duly noted.
Any further comments?
I move for favor.
All right, is there a second? not receiving a second, the bill is not given a favorable report.
Quorum? Is this a quorum?
Well, we started with a quorum, and so because people leave doesn't make it not a quorum. Clerk, will you call the next bill?
Huh?
House Bill 60 by Representative Colvin.
So I'm going to carry this for Representative Colvin. What this is a bill to protect people that have diminished capacity. We passed a bill a few years ago that dealt with this for elderly. Well, I do have, thank you, Senator, but I do have a couple of amendments. The first amendment I've passed around is refers to on line 5, replace line 33 on page 2 with the following. That's basically changing it from 19 years to 18 years. This came at the request of the DAs. And then the other change is rather than come from the commission of the crime, it'd be the discovery of the crime. So I would introduce that and make a motion to adopt that amendment. Second from Senator Bell. All in favor say aye. Opposed? Okay, the amendment's adopted. All right, the second amendment I've got that I passed around to you is dealing with the I was concerned about some of the language that was in there on page 2 of the bill for financial exploitation, because especially when we're dealing with unauthorized control, because and authority, because the person that has the power of attorney, they are the ones that they make the decision, they determine what's authorized. So I got LSA to work on this, and so I would move adoption of the amendment. Okay, there's a second by Senator Elliott. All in favor of the amendment, say aye. Opposed? All right, the amendment's adopted. I will note that Mike made a comment that I did not see in our package, that a consideration that we should consider amending regarding venue, and I would suggest that since we don't have that together, we're going to, in keeping with the chairman's philosophy, we're not going to deal with that today, but I would suggest we take a look at that at the floor. So now I'd move favorable amendment, favorable report, second from Senator Bell.
Mr. Chair, if I may, I'd like to talk to y'all about this before we get it to the floor. I've got some. This is a good thing we need to proceed with. I'm not trying to indicate that, but when you start dealing with these matters, you're tearing into families and to some very personal matters of proof and things that are going to be hugely involved, especially when you have criminal aspects to this, as what we're doing here. So I'm hesitant on some matters. I'm just uncomfortable right now, but I'm with you.
I appreciate that, and that's kind of what got me with my amendment is the way we're handling somebody operating as whether they're trustee or power of attorney. Specifically where some language was originally talked about in terms of that withholding money. Well, you may, if you have a spendthrift, you're supposed to withhold the money. It's for their own good.
Well, that's one thing. Then the other is you have to go back to when and if this power of attorney is valid in the first place, and the proving of that, which may have been in a civil matter or not. And then you can put banks that rely on these documents, and maybe anyway. I got lots of questions on that.
Okay, understood. Clerk, if you call the roll, please.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott,
Aye.
Senator Gavan.
Aye. All right. Bill's given a favorable report. So I believe next up we're on
SB 97.
Yes.
Say the best for last.
Coleman Madison.
Well, not quite last.
Not? Okay. We've had, SB 97 is a bill to protect children against loaded firearms that are in the home. We brought this up before. I do have an amendment to this bill. Mr. Chairman, you have that. It is changing
Yes,
the
Senator.
penalty to a Class C misdemeanor. I want to thank the attorneys who brought this to my attention. It's really not intended to be punitive. In Montgomery, even yesterday, I think it was, there was a huge public hearing with people at City Hall concerning gun violence and things like this. And as I sat there and listened to it, we could duplicate that in any city. I know in Birmingham, I've just stopped watching the news because every time I turn on something, it's about somebody's getting shot. But the saddest part is that when you find a situation where you have gun death that involves a child, especially in the home, as a parent, I would not know how to even live with that. And so all this does is basically creates an offense or misdemeanor, Class C, for the storage of firearm that if a person committed, it's basically negligence on the part of not storing your firearms properly. It is really intended to get the attention because the sheriff's department, most of them will give you gun safeties mechanism to put on your guns, or you need to lock it away so that children can't get into it. So that's basically the essence of this bill, and I would ask for a favorable.
So we need to adopt the amendment, I believe. So I would move adoption of the amendment. Is there a second?
Second.
All right. So all in favor of adopting the amendment to change it from a felony to misdemeanor, say aye.
Aye.
Opposed? All right. The amendment is adopted. And so
I move the bill
okay.
as amended.
You want to be recognized?
I want to be recognized.
Okay. Recognize Senator Bell.
And I understand your reasoning behind this, but where I live in the country, when my kids were born, both of them, same thing happened to me. I bought my kids 2 guns, a long gun and a pistol. And my kids have been raised with those guns. And to this day, they can walk out and shoot those guns and do what they want to do. And I just can't support anything that takes that away from, we live in the country, and that's just every day for us.
I understand. My folks grew up in the country.
Yeah,
I'm from
and
the
that's
country,
just-
believe it or
and
not.
that-
I
and
live in
that's
the city now.
That's just every day, and I understand that, and I just can't support this bill because
I understand, and I can
I would
respect
be in
that.
a lot of trouble based on how we live our life where I live.
Well, let me just say this. There's no police enforcement that's going to be in your homes. The only time that really,
You never know.
well, it's about negligence. It's about taking responsibility. So the only time that would ever come into play is that if something tragic happened, a child was shot or killed, then this law would come into play. Whereas now you're looking at, okay, where they probably stored. And the bottom line is that in the absence of, there's no penalty, nothing to get the parents' attention. So if something like this happens, if it happens one time, then maybe the rest of the parents would say, hey, we need to secure ours. Now, your kids, it probably won't ever happen. They've been trained to do it. And again, nobody's going to be in anybody's home, period. The only time this is going to ever come into play is that something happens. And we are trying to get people's attention to understand that this is, or if it passes and becomes a law, that there's a law against that. And as a parent, you have a responsibility. As lawmakers, I think we have a judiciary responsibility when we took an oath to protect. And so that's what this bill is about.
I guess my kids are home alone, and I've got a gun lock on my gun because that's the first thing I do is throw those in the garbage. I'll have to be honest. And somebody's breaking in the home, my kids are trained. Shoot them. It's just the way it is. But if they have got a gun lock on there, then I think it puts my kids in danger. My kids are taught. If somebody breaks in the home and I'm not there, shoot them. I'll come home later and we'll deal with it. But that's just. It's just what this. I guess it's the way we live in the country.
And you can continue to live like that. This is not saying that it's not requiring you to do it, but all it's saying that, well, there are a lot of laws that we have. You can't make people do it. And really, the only time, it's just like you have a stop sign that's out there. It says stop you. Some people stop, some people don't. The only time it really comes into play is that if an accident happens, it causes something. Now it's we have a law against this. So now, but in the absence of having nothing to address it, that's all I'm saying. When something happens, then what's the penalty? What's the red flag? Nothing. So for those people that live with guns and people are familiar with them and the kids are comfortable, fine. But again, and that really none of that has anything to do with it. This is about raising the flag to get people's attention that there are people that are out there, and you do have children that are being killed every day, because there's no law against it. So, okay, so child got killed, go to court. What happens? You all attorneys, all of you guys are attorneys sitting here. So what happens? Tell me.
Don't do criminal.
Huh?
I don't do criminal.
Well, it would be nice to just put something out there to let parents know, say, you understand, especially if you are a parent that you not train your child that you just got a guns laying around, and there are folks that do.
Senator, if I can make just a personal comment, my dad still loves to tell the story when I was not old enough how to drive legally. Now, I'm not saying I didn't illegally, but I wasn't old enough to drive legally that I had a Massey Ferguson 285 sitting in the driveway, and I had a scabbard strapped to it. And when I came home from school, I grabbed my rifle and I put it in that scabbard, and I drove wherever I was going to go hunting. And if it wasn't deer season, I came home and got a shotgun and put it in a scabbard and hopped on a horse and went where I wanted to go, starting in probably 6th grade. So this is not something I'm going to be able to report. So I think you've already made a motion. Is there a second?
Can I second my own motion?
Afraid not. So for failure of a second, the bill does not get a favorable report. Clerk, if you'll call the next bill.
Senator Cornley.
Okay, that'll be fine. Yes, sir. So this is a bill that Pardons and Parole brought early in the session, and we've been kind of working with the DAs to come up with some language to make sure that it was doing what it was intended to do, and that intent is to say that if you are issued early release under the mandatory release, you commit an act that violates your probation or parole, that you are you're going to go back to prison. You're no longer eligible for that. And a part of that is because they get back in, they get, released again, and they come back again. And this is just to kind of keep that revolving door from happening and put them back in there and say you're going to serve out the rest of your sentence. You had an opportunity and you failed. It doesn't count towards a concurrent or a consecutive sentence as far as the time goes. That was something that we were looking at. So with that, I'd ask for a favorable report.
Okay, motion for a favorable. Is there a second? Second from Senator Albritton. Clerk, if you'll call the roll, please.
Senator Albritton. Senator Bell.
Aye.
Senator Cornley.
Aye.
Senator Coleman Madison. Senator Elliott.
Aye.
Senator Gavan.
Aye.
Favorable report.
So the bill is given a favorable report. Thank you all, and same time, same channel next week.
Hopefully not. Same time.
Take care now.